the Department of Labor recently provided additional guidance for plan administrators seeking to comply with the new participant-level fee disclosure regulations. This guidance, in the form of a Field Assistance Bulletin 2012-02, contains 38 frequently asked questions helping to clarify the provisions in the regulation itself. We are very appreciative of this guidance. We think it will be helpful to plan administrators in fulfilling their responsibilities. However, there is one question that we are concerned about and seems to break new ground. In particular, it's question number 30, and it concerns brokerage windows. Now, under the regulation, brokerage windows or similar arrangements are not considered to be a designated investment alternative. Information needs to be provided about the costs of the brokerage window and how to use it, but the investments that can be obtained through the window are not considered designated generally, and so generally information about those investments doesn't need to be provided to participants. However, question 30 seems to break some new ground in suggesting that there is some responsibility of plan fiduciaries to monitor the investment selections made by participants and beneficiaries through the brokerage window. In particular, the regulation says that, quote, plan fiduciaries have a general duty of prudence to monitor a plan's investment menu. If, through a brokerage window or similar arrangement, non-designated investment alternatives available under a plan are selected by a significant number of participants or beneficiaries, an affirmative obligation arises on the part of the plan fiduciary to examine these alternatives and determine whether one or more of such alternatives should be treated as designated for purposes of the regulation. Now, this is surprising, frankly. It was not something that had been discussed leading up to the issuance of the regulation, and so we are concerned about exactly what does it mean to treat an investment alternative available through the brokerage window as designated. There's also a safe harbor provided which says if the plan administrator provides disclosures with regard to at least 3 of the investments available through the brokerage window that have materially different risk and return characteristics to meet the broad range requirements of the directed investment regs, those 3 core investments. If you provide disclosure on them plus disclosure on any investment that more than 1% of the participants and beneficiaries have selected through the brokerage window during the 90-day period leading up to the annual disclosure of greater 5, if you provide this new disclosure, they won't take any enforcement action. Now, we find it surprising and perplexing that this issue came up so late in the game. We are very close to the deadline for compliance. We continue to have a dialogue with the DOL as to exactly where their concerns are, and we hope to find some more common ground in the weeks ahead. We'll certainly let you know as developments occur in the future.